Hi, welcome to the 60th and the last session on IBC, in which we are talking about liquidation process. And this session and the previous session will together give you a clear idea on how to successfully do liquidation of the corporate debtors when the resolution plan fails. So in the previous session, that is session number 59, we have taken up a specific case of SR foils and papers, where we said because of a severe financial crisis, it had to go into a CIRP. CIRP failed for multiple reasons, and then liquidation order was passed. And while the liquidation was going on, suddenly the assets of the company were actually taken back by the RICO after cancellation of a lease, and they have rather said that they have an order for eviction from a competent authority, but the order was not produced, and hence the liquidator moved a petition with the adjudicating authority and had two major prayers. Number one was to set aside this cancellation of the lease order, or at least stay the lease order cancellation, and then the other one was to actually cancel the eviction order passed by the competent court. When these two prayers were sought by the liquidator from the adjudicating authority, what did adjudicating authority say and what happened after that, and what other challenges did the liquidator face, is what we're going to understand this session. So while he prayed for two reliefs, what happened? Meanwhile, the tenure of the President of the Honorable NCLT Principal Bench, New Delhi, came to an end, and considering the urgency of the matter, the moment the term comes to an end, you understand as law students or lawyers or various people that the case was understood by a particular judicial member of the bench. He had fair understanding, and suddenly, as he retires and a new member on the bench comes and takes up the matter, it will be absolutely a fresh matter for him, and therefore it will take enormous amount of time to reach any logical conclusion. Therefore, the liquidator in this case, looking at the retirement of the president, he sought certain other relief. What was that? The liquidator filed a writ petition under section 226 of the Constitution of India before the Honorable High Court on August 8, 2020 for issuance of a writ of mandamus or a writ of any other nature. That writ was listed before the Honorable High Court of Delhi, wherein the Honorable High Court, whilst noting the fact that the term of the acting president of the Honorable NCLT has been extended by a period of 1 month with specific effect from August 5, 2020, accordingly requested the Honorable NCLT to consider the request for early hearing of the application filed by the liquidator. So here see, when we have filed a writ petition seeking a writ of mandamus, instead of actually giving a writ to the NCLT members, the High Court merely made a request that now that the term is extended for you by a period of 1 month, please consider the request of the liquidator and maybe take up the matter if it is convenient for you. So we are seeing a lot of things at the same time. You are also seeing interjudiciary correspondence. The high courts will not generally write writs like this to the tribunals. In this case, they only made a mere request instead of giving an order of writ. In view of the aforesaid order passed by the Honorable High Court, an application was filed before the NCLT on August 1st, 2020, again seeking cancellation order passed by RICO, was scheduled for listed hearing on 17th August 2020. On the date of hearing held on August 17, 2020, none appeared on behalf of RICO. See, liquidator made a request. The Honorable NCLT gave a date that we will post this matter for the hearing on a certain date. And on the date which was given by the NCLT, no one appeared on behalf of RICO. And the Honorable AA passed an order and directed RICO not to take possession of the properties of the CD based on the cancellation order dated June 11th. That means you can understand what is happening here. The liquidator prayed for a stay on the cancellation order. The NCLT posted the matter. None appeared from RICO to oppose the matter, and therefore NCLT passed an order and directed RICO not to act on such order and not to cancel the lease granted to the SR coils and paper. What happened next? So you can see almost that there is a logical resolution to the first major challenge faced by the liquidator, that the assets and its lease were cancelled, and he had a major threat to face that the assets will go back to RICO. Now he has secured one order from NCLT which almost gave him a assurance that the assets will not go back to RICO, and therefore NCLT ordered the RICO not to take possession of these assets. Now, while the dispute is still pending, you need to understand this case. This is about Regulation 37A of the IBBA regulations on liquidation. We have covered these regulations in the previous sessions, and we understood what is Regulation 37A. To tell you what is Regulation 37A, what it says is, wherever the assets could not be immediately disposed, where they are not readily realizable, maybe the liquidator can consider assignment of these assets subject to the outcome of any other judicial proceedings. So in assignment, what happens is the rights are transferred. What kind of a rights? These rights are not ownership rights nor the lease rights. These rights are the rights to make a legal representation and fight out the battle are transferred by way of an assignment, and the assignee will fight the matter on behalf of the liquidator in future, and if the matters are settled in favor of the assignee, then they will get the possession of the properties or get the ownership, whatever is prayed for. So this is Regulation 37A, which was newly inserted into the liquidation process regulations. Why was it inserted? We need to understand the logical background. Erstwhile, until this Regulation 37A was inserted into the liquidation process regulations, there were only two options. You sell as a going concern, or you sell an asset as a standalone basis, or you disown the asset. But there was no provision for assignment of the asset earlier, and this looked to be the need of the hour. So what regulator had done is, he had amended the regulations and added a new regulation which allowed assignment of the assets which will form part of the liquidation estate. Fine. So this is the background. Let's see what happened and how did the liquidator capitalize on this. Why should he capitalize? The logical reason is because the lease was cancelled. The prospective buyer of these properties will be hesitant to buy. He will always feel that if I invest a lot of money on these assets now, and in the future, if the cancellation order is upheld by the higher courts, I will have no recourse, and after investing a lot of money, the properties will go back to RICO. This is a challenge that liquidator is facing. Therefore, when he looks at the assignment, it looks like a boon to him. I cannot sell the asset because the buyer is not willing to buy, but at least I can assign the assets which will be subject to outcome of the court's decisions in future, and maybe this will be attractive to the buyers to buy the asset, or at least get the assignment in their favor. So let's see what happened. It was discussed that since underlying assets being not readily realizable, an initiation of sale process under Regulation 32-33 of liquidation regulations also subject to outcome of the application filed before Honorable NCLT. Therefore, it was decided to explore the opportunity for disposing of this asset by way of publication of sale notice under Regulation 37A of the liquidation regulations pertaining to assignment of not readily realizable assets to solicit offers from the investors, as I said. However, though there was no clear position under the law whether these properties can be assigned or not, understanding the new regulation that it allows the assignment, the liquidator wanted to be extremely cautious in not really getting into a legal trap. So therefore what he did is he followed the best practices that were advised by the IBBI. So what were the best practices that he had to follow? He had to always keep the following principles in mind. Number one, acting in the best interest of liquidation interest. Whatever assignment that you're doing, if you think it is in the best interest of the liquidation, yes, please proceed. 2. You must seek maximum consideration for the assignment. So, the whole objective of IBC process is to maximize the value of the assets. So, you seek that. Third, you must always act in consultation with the stakeholders consultation committee. Take their advice. Then, assignment through an auction, or if an auction is not possible, at least do the assignment on an arm's length basis without having any bias or without having any personal conflict of interest in the matter. Then the last two, assignment shall be subject to section 29A of the code, and lastly liquidator to be reasonable, fair and should act in good faith. These are the 6 principles that the liquidator should follow according to IBBI, and therefore he followed these regulations and tried to release an auction notice. What is he auctioning? He is auctioning those 2 plots which were earlier threatened to be taken over by the RICO. Now that he has an NCLT support, he is trying to sell these assets subject to assignment by way of a fresh auction notice. Though after this notice, 4 parties have shown interest in the property, they have not deposited the EMD amount and hence the attempt failed. So, firstly we went into CIRP failed, we went into liquidation. In liquidation we saw multiple challenges, some challenges were resolved, and then luckily a new section or new regulation 37A allowed the liquidator to assign. Therefore, he made a publication of the auction notice under 37A. Now that also failed. So you can understand the fate of the liquidator and the fate of the corporate debtor. Desperately, he made a final attempt. After the final attempt was made, the liquidator received a final offer from prospective buyer for a price of 14 crore. Now see, as I was telling before, at the time of CIRP, the price offered by the resolution applicant was 32 crores. And the financial creditors of the COC was not happy. Therefore, they thought they will go for a liquidation. Now, under the liquidation, a desperate attempt for auction under 37A was made, and now you got an offer for 14 crore. So now think of wisdom. I'm not trying to say that this was wise, not wise, but at least a decision to go into liquidation was made by COC, maybe in anticipation of a better payment or maybe for technical reasons. But in the liquidation, the offer that they got is less than 50% of the offer that they got in the resolution process, right? This is only purely an observation that I made. Fine. So you can always understand cases from different perspectives like this. Now what happened after that? While 14 crore offer was made, they planned to assign the assets to the bidder in the auction. While this was happening, RICO filed an application with the adjudicating authority against the liquidator, stating that I have already cancelled the lease against which these guys have applied in a court of law, and the matter is already sub judice. While the matter is sub judice in a court of law, the assets which are forming part of the subject matter are now being sold by the liquidator, and therefore they immediately sought a stay on such sale process. Now look at the entire scenario. Liquidator is trying to resolve the matter, and he is trying to create best interest for the corporate debtor and also serve the SEC. Third parties outside are posing more challenges to him, trying to litigate the matter. Now while this is being done, the liquidator's team is trying to mitigate the matter by explaining to the judges on what is the scenario. Now you can see, however, the liquidators counsel apprised the adjudicating authority that the liquidator is only assigning the rights on the property but not actually selling them. Now, though adjudicating authority did not restrain the liquidator from assigning the property, he decided to keep the process on hold as a matter of fair practice, because there is a dispute that is already created. Now he cannot go forward with the assignment. He thought, as a liquidator, it is better that I refrain from assignment of this particular asset. Look at how cautiously the liquidator is proceeding in the whole matter. He is taking legal advice. He is sticking to the principles. He is sticking to the principles of natural justice. He is also looking at what is expected from him as a liquidator and how does he maximize the value of the assets. While he is doing that, the external forces are throwing more challenges at him and he is getting trapped again and again. Now let's see how will he overcome from this scenario. As per the advice of SEC, so as per the advice of SEC, an application was made to adjudicating authority. It gave clarification that the nature of transaction is only assignment and not sale, further clarifying that the transaction is in the best interest of the CD and SEC. Now see, what we are doing is, earlier adjudicating authority neither expressly allowed the assignment nor expressly rejected the assignment. It put the liquidator in a fix, and then liquidator ethically took a decision that I am not going to proceed with the assignment. When he communicated this to the SEC is saying, boss, yes, we understand your fix, but let's do one thing. Let's approach NCLT and take a specific permission to assign the properties to a auction bidder. Now see what happened. On being convinced with the arguments of the counsel of the liquidator, the adjudicating authority passed an order to immediately proceed with a fresh public announcement for expression of interest for assignments of the rights in the properties. Now liquidator is free to actually go with the public announcement for auction. Now he started a fresh bidding process. It was decided that this should be done online, and therefore online bidding process is to be conducted. The reserve price was, so they started a fresh bidding process and they fixed the reserve price. This time the reserve price is 14.5 crores. Remember, the offer made in the bidding process was 14 crore. They increased the reserve price to 14.5 crores this time and started a fresh bidding process, which is supposed to be an online bidding process as per the instruction of the NCLT. The liquidator received 3 bids. Good news. And the highest bid was for 14.5 crores. Nobody crossed the reserve price. Now, when nobody crosses the reserve price and all the 3 bids are nearing the same price, it is a tie. So, we are almost having a Super Bowl scenario in this bidding process. So, how will you break the tie between the bidders? So, they thought of multiple options. How should they break the tie and how should they actually get a revised price? As all the bids were nearly equal, there is no clear winner. Hence, an inter-se bid for the bidders was to be conducted, for which an application was made to AA, and the same was approved on 7th October 2022. So what happened is, now when I start a fresh bid, I am not going to allow everyone else to participate. Only those 3 bidders who gave the highest bid so far will now participate in this bid, and one of them will emerge to be a winner who will actually give the highest bid. So therefore, all of them will have to come back with a revised bid to come as a winner. Eventually, an offer for 21.21 crores was received, and the same was approved by SEC and allowed by AA. Now, we say that lapse of time can act like a poison, right? But sometimes the lapse of time can actually act in the best interest of the CD and also SEC. Earlier offer gave by bidder under liquidation was 14 crore, reserve price was 14.5 crore, all of them gave a 14.5 crore bid approximately. Now in a revised bid, inter-se bidding process, the highest bid is 21.21 crores, which is almost 50% more than the current bid, which is a great news for SEC. Hence, SEC approved and allowed. It was also allowed by the adjudicating authority. Everything seems so picture perfect right now, and we are believing that this is going to be a conclusion of the entire liquidation process. But no, there are some more things that have happened after this. What happened then? While this is going on, the liquidator discovered the company has some registered trademarks, which he thought can be sold for a value. Hence, he published a notice for sale of trademarks by e-auction. The trademarks were successfully sold in e-auction. However, the bidder failed to deposit the balance sale consideration. He only deposited 25% and the balance did not come. Hence, the 25% amount of advance was forfeited and the sale was cancelled. Eventually, they were sold in the 4th e-auction attempt. Only trademarks. They were sold, but that is not the end of the story. After the trademarks were sold, it emerged to the notice of the liquidator that there were a lot of similar trademarks registered by third parties. Now, when I am talking about trademarks, you need to understand that once a trademark of a certain nature in a certain class is registered, a similar trademark cannot be issued. However, a similar trademark can be registered by a trademark authority provided the original trademark owner gives a no objection certificate. Now, when the liquidator investigated, he found that the CD himself gave an NOC to the registrar to register various other trademarks which are similar in nature. Now you see what we are doing. One side, the liquidator is struggling so hard to bring some meaningful conclusion to the story, while everybody is trying to throw some challenge, and corporate debtor primarily created a major challenge in the process of sale of the trademarks. So he has created similar trademarks in favor of third parties. Now the buyer of the trademark will come back and say, boss, if there are multiple trademarks of the same nature, why am I paying you money? I am not interested in paying you money, so the trademarks cannot be sold now. This is a new problem faced by the liquidator in this scenario. Then what happened? The liquidator took various initiatives to cancel the trademarks that were registered by the registrar. So he went back to the registrar and said, boss, see, while the liquidation is on, I am the boss of the scenario. If there is any NOC to be given, I should give the NOC. Corporate debtor has no right to give the NOC. Whereas he gave the NOC and you registered the trademarks. Therefore, now you need to cancel all these trademarks, right? Because I have not given the NOC. Then he said, there are some trademarks which are still pending to be registered. I have a strong objection. Please do not register these trademarks. Then the registrar acted on the request of the liquidator and then cancelled all those trademarks which are similar, and also had noted the objection of the liquidator for similar trademarks which are pending registration. Now this action of the liquidator, timely action I would say, paved way for resolution of the trademark dispute and purchase of the asset at the fourth auction by the successful bidder for trademarks. But the main bid for the lands is still the matter, which was for 21.21 crores. We will see what happened eventually. Now, while this was happening, the liquidator found that CD had filed some charge related documents with the ROC, and they had some assets which were sold already. So, while I am appointed as a liquidator, I am going through the process of liquidation, and somebody randomly sells some property belonging to the company without even intimation to the liquidator, or at least some day prior, which is in the nature of an avoidance transaction. So the liquidator dig deep. He said, where was this asset? Why was there a mortgage or hypothecation created on this asset? When he dug deep into the scenario, he was informed that a financial institution had lent a sum of rupees 10 crores, a lender, right? And took charge on specific properties of the company. The lending was 10 crores and the property was charged to the lender. Then the corporate debtor offered 3.5 crores to the lender as a repayment, and the lender took 3.5 crores and released the property against 10 crores worth of loan. And these properties were eventually sold by the corporate debtor. So now the point is, can I inspect this transaction? Will this be an avoidance transaction? If he has to prove that it's an avoidance transaction, then there are four principles that you know, PUFE. Now, when he dug deep into this transaction, he found that this is an undervalued transaction. The assets were actually worth 7 crore, but they were sold at 3.5 crore by the company, and therefore he thought this is an undervalued transaction. He approached adjudicatory authority. Adjudicatory authority asked the liquidator to seek an expert opinion, because I am not an authority to decide the value of the asset. That should be decided by the third party, and that third party's decision is binding on everybody. That's what the adjudicatory authority said. Now, what did experts say? Experts said that yes, the value of the property that was sold is worth 7 crore, but the sale consideration is only 3.5 crore, hence it is a clearly undervalued transaction. Therefore, now the liquidator will have a right to call for the balance 3.5 crores from the buyer of the property. Okay, this is another problem that the liquidator has sorted out while doing the liquidation. Then there is another scenario. another challenge that is faced. The liquidator has seen that the trademarks of the companies were already assigned to third party and third parties are happily using the trademarks. When third parties are using the trademarks without any payment of royalty to the company, it is a huge financial loss. Therefore, what he did is he sent a notice to these users saying that because these trademarks belongs to the corporate debtor for which I am the liquidator, you shall pay a 2% royalty on the value of the trademarks to me urgently for the period that you've used these trademarks. Then the user did not pay nor did he respond. Hence, an application was moved to adjudicating authority for grant of royalty. The adjudicating authority ordered the user to pay an amount of rupees 56 lakhs per annum as royalty for continuous use of trademark from 2019. However, the user did not pay any amount in spite of an adjudicator's order to pay 56 lakhs per annum. Now, therefore, a case of contempt is filed against the user, which is still pending. We will see what will be the outcome of that case eventually. But while, see, this is almost fifth or sixth challenge posed against the liquidator. This is on one side. Now, there is one more challenge. What was that challenge? The challenge was that the liquidator has seen that the company has some fixed deposits made with State Bank of India, SBI. And the State Bank of India has to return these fixed deposits. So he went and asked State Bank of India, boss, you have some fixed deposits with you. These fixed deposits are actually part of the liquidation estate. Therefore, I request you to release them. Now, the State Bank of India very clearly told them that, boss, these fixed deposits are under lien because I have issued bank guarantees to Customs Department against this fixed deposit. Therefore, unless Customs Department gives me the original bank guarantee documents, I cannot release your fixed deposits. Now, he wrote multiple times to Customs Department to give back the originals. The Customs Department did not heed to his request, while SBI kept on telling that unless I get the original documents, I cannot resolve the matter. Hence, he made a fresh application to adjudicating authority and sought an order directing cooperation from both SBI and Customs Department. Now see what adjudicatory authority did. Adjudicatory authority said, I have no idea whether the bank guarantee is invoked or is it currently pending. Therefore, first I need to have a clarity from both the SBI and also from Customs Department that the bank guarantees are not yet invoked and they are currently valid. That's when I'll pass an appropriate order. Therefore, it asks the liquidator to get a confirmation from both the parties. In spite of such an order from the adjudicating authority to cooperate with the liquidator and confirm the matter, there is still no response from the Customs Department. However, luckily for the liquidator, SBI has come forward to remit the amount, and we hope that the matter will be soon resolved. So what are the learnings from this case, and what did you find out from this lengthy case study which spanned over the sessions 59 and 60? We have seen that in spite of all the challenges, ultimately the liquidator was successful in getting a proposal for 21.21 crores for the assets of the company. He had sold trademarks separately. He could successfully force the users of the trademark to pay some royalty. He had pressed case against SBI for refund of the deposits, and he has done various things during the process of liquidation to maximize the value for the SEC, and also he has taken multiple actions in the best interest of the CD, right? While this is all fact, what are the learnings for us from this case? As I said, value maximization, then fairness and transparency. He consulted SEC every time. He stuck to the principles. He acted fairly. He went by the principles of natural justice. He went by the lines of ethics. Efficient handling of complex situations. He always took legal help. He went back to SEC. He went back to adjudicatory authority. He took proper measures, reliefs at the appropriate time. Then we understand importance and ways of tracking assets of the corporate debtor, including intangible assets like trademarks and value maximization thereof. This is what we learn from this case study. And finally, you must ask me, what is the great value add that the liquidator has done to the liquidation estate and to the SEC? How did this whole case conclude? Who got how much money? So this is what explains who got how much money. On account of assignment of the two properties which were leased out by Rico, he got 21.21 lakhs, out of which liquidation cost was set aside and the balance was distributed actually. Then avoidance transactions, he got back 2 crores 85 lakhs approximately, and then against that he spent 9 lakhs 35,000 liquidation costs which were recovered and the balance was distributed. Now you see almost 20 crores from assignment, 2.75 crores from avoidance transactions. Brand's royalty is estimated at 2 crores 72 lakhs, so he got some money from there. Then sale of other assets including interest thereon, he got 66 lakhs and this was distributed. Again, the total realization is here, net amount of distribution is here. Forfeiture of EMDs against the successful bidders who paid the advance but never paid the balance money, he got 54 lakhs, and all other realizations there was 68 lakhs. And now see, finally he got some 27.34 crores for the SEC, and the bid in the liquidation was 21.21 crores. All these added together, the SEC could get a total realization of 27.34 crores, and the liquidation was eventually successfully completed. This is one of the tremendous success stories, and this has taught a lot of lessons to the insolvency professionals, either as a resolution professional or as a liquidator, as to how we should stay calm, apply mind, and find out the ways to maximize the value for the SEC. So friends, this brings us to the end of this 60-hour marathon on IBC, which had 60 sessions, and this was the last session. Thank you so much for patient hearing to all of you. Have a great time.